Well, welcome everybody to the summer online course, uh, Wills and Estates, and glad to have you all. And for some of you, this is your first experience with an online course. So I want to take you through the materials that we're going to be using and how we'll interact with each other this summer. What you see on the screen is the Twin page. Now, I know the law students are probably familiar with Twin, uh, and I also know we have some accounting students, and this might be your first time using Twin. So you should have gotten a link to the Twin site by now, and this Twin site will be available to you all summer and very easy to use. It's similar to Blackboard. I actually think it's a better interface, but one of the things about Twin that I think you'll like is you'll see at the top up here that you can link to Westlaw. And so, you'll have a Westlaw password as well. Westlaw is a place that you can look for cases and statutes and articles about your area and your jurisdiction. One thing I should start by saying is that because this is a small class, each of you can choose the jurisdiction that you want to cover in this class. So, if you're going to practice in Massachusetts, you can use Massachusetts as the wills and estates law that you're going to go by this summer, and that's how I'll evaluate you as well. So I'll be either learning that law with you or working with you on law that I already may have had some background in. So choose the jurisdiction where you think you're going to take the bar if you're going to be a lawyer. Choose the jurisdiction where you think it'll be most useful for you if you're an accounting student. And you'll let me know that throughout the semester, and I can work with you on that jurisdiction. Now, we're going to see that the answers are not that different from jurisdiction to jurisdiction, but there's some variation. And so really what we're going to be doing is, as a class, focusing on what questions come up in the area of wills and estates. And then you'll look for the specific answers for your jurisdiction, and I'll talk you through those. Now, you'll notice on the Twin site a few things I want to point out. We've got, first of all, these Cali lessons. They are multiple choice questions that are set up through the Computer Assisted Law Institute, and it is something that is just some more questions that you can practice with on various aspects of wills and estates law. You'll have a password for that, and you can take those quizzes as many times as you want to. The course materials. I'll open up the course materials site real quick. If it'll let me link to it, it's opening. It's going to, there we go. And so you can see that the course materials are organized by week. And so week 1, we're going to be doing intestacy, and week 2, we'll be talking about adoption and bars to inheritance. And week 3, we'll talk about capacity to make a will, and so on. And so we have 8 weeks worth of folders with materials for each week. And I'll send you out an email saying what you're expected to do for that week. I'll also send you what the assignment is for that week. And so these are where you're going to find all your course materials. There'll be some cases, but there'll also be mainly some PowerPoint, some problems that you're going to work through over the semester. We will be doing live discussions, and the way we'll do that is I will, from time to time, post on that live discussion something that I expected you to get out of this particular week's assignment, and you are welcome to post responses or questions on that live discussion. We will also, on a weekly basis, have opportunities for you to talk to me live, and ask questions live. Those sessions won't be mandatory, but I'll send you a link each week that we can do, any questions that you have that you want to talk to me specifically face-to-face and work through, not face-to-face distance-wise. So we'll be doing that as well. Web links are going to be helpful. The web links, I'll post various current articles about what's going on in wills and estates. Also, the lectures will be linked on the web links, and you'll be available to look at the lectures at your convenience. You're supposed to do them one a week, but if you want to binge watch and do them earlier, certainly they're going to be available for you to do so. All right, and so you'll notice then that the Twin site's very easy to navigate. For example, if we go back to the course materials, you get your week 1 materials, and we're going to see that there are a couple of PowerPoints on intestate succession. Each PowerPoint will have a corresponding lecture with it as well, so that I will talk you through those PowerPoints. And then again, Westlaw is where you will find the statutes for your specific state, and I can help you through those too. If you've never used Westlaw before, please feel free to contact me, and I'll be glad to work with you on how to use Westlaw. Now, one important thing, obviously, that we'll find in the materials is the syllabus. And there's a lot of good information on the syllabus. You can download it from Twin, easily downloadable. You'll notice that when I clicked on Twin, on options, one of them was download, one of them was open. So I downloaded it and pull it up in my downloads, and there it is. And I'll even make it bigger on the screen. So this is, again, it's a 3-hour class, and let me give you my information. This is important. My office phone is 662-915-6918, but I'll probably be more easily reachable at the cell, which is 662-701-0300. And you can see my email address is igershen@olemiss.edu. You can also email me through a link on Twin. That email is linked to my Gmail account. I check them both, so it doesn't matter. My preferred account is my Ole Miss account, but if it's easier for you to email me through Twin to my Gmail account, that's perfectly fine. Now, again, the description of the class, I'm not going to read the syllabus to you, but I'll give you some highlights. There are related classes. This is the basic beginning class for estate planning, and we're going to talk about wills, intestate succession, trust, some probate administration, trust administration, and guardianship, because the class is not just focused on property passing, but it's also focused on people, taking care of people. So people with special needs, people who are minor children. Your clients need to think about how they're going to plan for those people in the event of death before those people become adults if they're minor children, or in the event, in some cases, if someone's got special needs, that's going to be a lifelong issue for them that you need to help your client address to make sure that person has the resources they need to be okay. All right, so we look at that as that's the class we're going to deal with. Some of you will take the Federal Taxation of Gratuitous Transfers class. It's a 3-hour class we offer in the fall at the law school. It's going to focus, we'll focus on estate and gift tax and generation skipping tax. We're also going to switch our focus to some extent in the fall to the income taxation of trust and estates, which will affect quite a few more taxpayers. The estate and gift tax has been limited to estates really that are in excess of $20 million. And I hope that you deal with those, but most of the estates you deal with will not be that size. They will be smaller. Some topics to be covered. You'll see in the list below. I list all the topics we're going to cover in sequence, and we'll get to that in just a minute. Our learning objectives. I want you to learn how to read and analyze statutes and cases related to wills, trusts, and estates. We're going to use problem solving to understand those concepts better and apply those concepts. We'll also have assignments for each section, and you'll have to complete those assignments using your chosen jurisdiction, and that will help you to apply the laws you're going to be actually using in your practice. The number 5, Roman numeral 5, compliance with ABA standard 310 is something that we have to put into our law school syllabi. The ABA wants to make sure that we're not just selling credits, and really that's partly because the Department of Education is concerned about educational institutions that aren't legitimate and really just sell degrees. And so we have to certify that there's some amount of work in the class and outside of the class that you'll be doing. And so, there's certain standard 310 kind of dictates that. But I'm not going to be looking over your shoulder to see that you do 90 hours of outside work. That's just a general guideline. You will be earning the credit in this class, and I'm sure you know, and I hope it's a good experience for you. This course also is designed with compliance with the University's Statement on Disability Access. There'll be captioning in the videos, and also if you need accommodations, please either let me know or let the Dean of Students here know, or if you're not a law student, make sure that you talk to the appropriate office about accommodating you, and we'll be happy to do that. Your exam will be a take-home exam. You'll have a week to do it. I'll post it on Twin at the top. I'll post it on Twin when I tell you it's going to be available. You can just start working on it then, and then it'll disappear at the end of that week. So you have a full week to do it, totally open book, open note, and it'll have 25 multiple choice questions and an essay question that will be tailored. The answer will be specific to your jurisdiction. So you'll put your jurisdiction on the exam. You'll tell me what jurisdiction you're answering the questions for. It's an online class, so I expect everyone to complete the assignments. It's the only way I know you're doing the materials. And so you will have either written assignments to turn in each week. There won't be burdensome. They're just a way to test to make sure you're understanding the material. The other thing that we will do is I have a link to something called Class Marker. You can see that in the week 1 materials. I'm going to provide you the link and login information. There'll be multiple choice questions that you take on Class Marker, and those multiple choice questions you can take as many times as you want to. What will happen is I will get an email from Class Marker saying that you've attempted the test, telling me how you did. And again, you can attempt it as many times as you want till you learn the material. So I really like this interface. It'll give you some feedback. It's a good way to test yourself on the material. It's a good way to make sure that I know you're doing the work as well. So the first week we're going to talk about intestacy, and that's going to be when we talk about what happens if we make no estate plan and the person dies without a will, without a trust, without any plan at all. What happens to their property? And it's a good starting point because it's really I think for any planning, whether you're doing accounting or law, your starting point should always be, to talk to that client and say, here's where you are today. If we don't do anything, this is what's going to happen. Well, in wills and estates, that's intestacy. If we don't make a will, here's what's going to happen. Now, if your client looks at that outcome and says, that's what I want to have happen, then you don't need to do anything for them. But it's very, very likely that will not be the outcome they want. And as we talk more about intestacy, that will become clear. We look at the materials in the twin marker under week 2, and we're going to talk about what is a child and what is adoption. Well, one of the primary beneficiaries that we're going to want to take care of will be children. And so what does it mean for someone to be a child when we talk about leaving property to a child? And how does adoption affect who is a child? Is the child still a child of his or her natural parents? Or is the child only a child of his or her adopting parents? And what if one parent dies and the other parent remarries and that person's new spouse adopts the children? What effect does that have on the children and their right to inherit? So we'll talk about that. We'll talk about how different states approach that very issue. As you'll find, there are usually just one or two possible answers, and so you're going to decide which choice your jurisdiction made. All right, we're also going to talk about bars to succession, homicide. For example, if I kill someone to try to inherit from them, we might expect that I'm not going to be able to do so, and that is going to be correct in all jurisdictions, although jurisdictions come to that point in different ways. So we'll talk about how they reach those decisions and what it means to commit homicide and what it means to be in a position where you can't inherit for that reason. But we'll also talk about a tool that you'll use called disclaimer that is a bar to succession that is actually one that you will choose to use. It's a way to do some what I call post-mortem estate planning, where a beneficiary decides not to take a gift from the estate for various reasons. And you might think right now, since we haven't covered it yet, why would you ever turn down an inheritance? Well, there are reasons, and we'll talk about what those are. All right, and then we get down to week 3. This is where the fun really starts, in my opinion. It's all fun, but we're going to talk about capacity to make a will. What does it mean to be of sound mind? What does it mean to have capacity? And we're going to talk about some challenges to wills. Undue influence is going to be a major one. And so when you are the person drafting a will, it is very important that you make sure that you have thought about potential challenges to that will. If you're someone challenging the will, you need to know what tools you have in your toolbox to make those challenges. So we're going to talk about capacity and what that means. We're going to talk about undue influence. We're going to talk about fraud, another category of potential challenge. Duress. Duress is pretty obvious. If somebody holds a gun to the person's head and tells them they got to make a will that leaves everything to them, or they're going to shoot them, that's duress. So that we won't spend much time on, but we'll spend some time on tortious interference with an expectancy as well. Now, when we get to week 4, we're going to get to the nuts and bolts. And this really is just the execution of wills. There's a right way, and there's every other way. And so I want to make sure you know how to make a will the right way that's going to be valid in every jurisdiction. So we're going to talk about best practices here and some steps we're going to take. There is no reason for any attorney to screw up the execution of a will. I'm going to repeat that. There's no reason for any attorney to screw up the execution of the will. We're going to go through those rules. It's cookbook law. It's not hard. And so, this is not an area that you want to make a mistake. And we'll talk about it. You'll see why when we get there. Now, the other thing is once we make a will, wills can be revoked. So we have to talk about the proper way to revoke wills as well. And we will do so. All right. We'll talk about in week 5 some will construction. All of these things really deal with interpreting wills. And so will construction and integration and incorporation by reference are really ways to interpret wills that allow us to refer to other documents outside of the will and incorporate them in the will. But the will construction issues are more about ambiguity and how we resolve ambiguity. Now, good drafting will help prevent some of the ambiguity, but numbers 13 and 14 deal with specific types of ambiguity. All right, number 13, lapse, deals with what happens when a beneficiary, somebody named as a recipient in the will, dies before your client does. All right, so client gives half of his estate to his brother. Brother dies before client. What happens? That's lapse. Lapse is what happens when a beneficiary dies before the testator. Ademption is when when the testator gives specific property, and that property is no longer there. So if I gave you my baseball card collection in my will, but I sold my baseball card collection while I was still alive, then ademption would take place because I've given you something that's no longer part of my estate. So we'll talk about how those two issues come up, and there are statutes that may sometimes help ameliorate that problem. But one thing that we should always think about, I'm circling number 13 here with my cursor, because lapse, you always need to think about what's going to happen if a beneficiary dies before your client. You should have an alternative. I give everything to my brother, but if he dies before me, or if he fails to survive me, then I want the property to go to plan B, right? I want the property to go name, whoever you want it to go as a second choice. So you should always work that through with your client. You should ask them, okay, well, you gave your baseball card collection to somebody in your will. What if you sell it? Do you want them to get the proceeds from that, or you just don't? You only wanted them to have the baseball card collection, and if you don't have it anymore, then they just don't get anything. But that's a conversation you should have with your client. We'll spend some time with that in week 5. Week 6, we move to avoiding probate. And we're going to talk about ways that people pass property outside of a will. And some of them are very, very effective and inexpensive ways to pass property. We'll talk about the pros and cons of using them, including will substitutes. But number 17 is when we get to really, really start talking about trusts. And revocable trusts are a vehicle that's being used more and more by lawyers who are planning estates as a really a better alternative even to a will. And we'll talk about why you might use a trust for clients instead of a will. Trusts are going to be more expensive for them up front, and that's one reason why maybe a will works for some clients with very smaller estates who need just a simple estate plan. But as they get more complicated, we're going to talk more about trusts, and we'll spend week 8 totally on trust and how they can be used as part of the estate plan. Now, week 7, we're going to talk about people and protection of people. And we were talking about planning for incapacity in number 18. And your job for week 7 will be to do an advanced healthcare directive. It will take you about 10 minutes to do it. I don't care what choices you made. I don't even want to see it. But planning for incapacity includes being, as a young person, and most of you are, I would assume, but in any event, as any person should have a plan in case you can't speak for yourself. And so we're going to talk about the Advanced Healthcare Directive as a directive to doctors and hospitals about who can make decisions for you in the event that you are incapacitated. We'll talk about how trust can play into planning for incapacitated as well. Family protection provisions and omitted heirs are really similar concepts, and they are really, to what extent can I leave my family out of my estate plan? We're going to talk about spouse. Can I leave my spouse out of my estate plan? Some of you are going to practice in states that are community property states. If you're choosing Texas as a jurisdiction or California, you'll be in a community property state, and so the spouse is protected through the marriage. Everything that comes into the marriage, all property, all money that comes into the marriage is treated as marital property and already belongs one half to each spouse. So that's a built-in family protection. If you practice in Mississippi or Alabama or Georgia, Florida, you're going to be in a non-community property state, a common law state, and you're going to see that maybe we do need protections. If someone leaves a spouse out of their will, we're going to see the spouse will have something called an elective share or something similar to that. Different states call it different things, but the spouse will have rights to take a portion of the estate, even if the spouse is left out. Also, omitted heirs, you can leave children out of a will, but what if the child wasn't born yet? What if a client says, I give my property to my children, Joe and Mary, and then Sue is born after the making of the will? Would Sue have any protections? And we're going to talk about that person as being an omitted heir, but a pre-termitted heir because she was left out before she even existed, because the will was written before she was in being. So we're going to have protections for those people as well. We'll talk about what they are. And finally, in week 8, we're going to spend a good amount of time on trusts. That will be how we'll finish off the class. And we'll talk about how trust creation is similar to will creation and how it's different, and why trust can be very, very protective of your clients. We'll talk about some specific types of trust. One you see on the syllabus called spendthrift provision, which will protect your clients' beneficiaries against creditors and against themselves, quite frankly. And then we'll talk about termination of trust. We terminate trust differently than we terminate wills, at least historically. The two types of termination are getting closer and closer together over time. Courts are getting less and less restrictive about termination of trust. And so we'll talk about that. And that's where we'll finish up. And then, all along we'll be answering any questions that you have. So there's the syllabus. And that, I hope, is a good introduction to the class. Again, my contact information is on the syllabus. and I'm happy to answer your emails, your phone calls throughout the semester. Good to have you as part of the class, and hope you have a great summer.